And our next speaker is Professor Gemma Andreone. Professor Andreone is director of the Institute for International Legal Studies of the National Research Council of Italy.
Thank you so much, Mr. President. Thank you to everybody. And let me thank immediately the organizers, the Korean Society for International Law, the Ministry of Foreign Affairs and the ITLOS for this invitation that honored me greatly. I also appreciated very much the warm and perfect welcome and hospitality. My presentation has today the sole purpose of the sole purpose of bringing to your attention some reflection in relation to the current evolution of international law regarding the relationship between the protection of marine environment and climate change. Many things that have been already said in those 2 days and are renowned, but actually my role is limited to raising questions on the basis of the study of a part of the recent practice in this domain. I will try to underline the complexity of the relationship between marine environmental protection and climate change, and to outline also the evolution of the obligation to protect the marine environment over time, as well as its characteristics and content, and then also to explore what is going on at international regulatory level, such as the PBNJ agreement, and also the practice of national and international judges, jurisdiction, who are increasingly called upon to dedicate and push toward a significant connection between the law of the sea, environmental law, and human rights. So the first reflection is the first reflection fully describes the complexity of the topic under analysis, because concerns the dual relationships, the dual relationship that exists between marine environment protection and climate change. In fact, climate change derives mostly from anthropogenic activities on land, and its consequences also extend to the marine environment, generating sea level rise, loss of biodiversity, acidification, and so on. At the same time, however, the activities carried out at sea, which are increasingly intensified, also thanks to technological development, also contribute to generating climate change. So these activities must also be regulated to prevent a worsening, but also to the sense of inducing state to reestablish and recover marine ecosystem, necessarily passing through a more responsible management of all human activities at sea. Coming to the more specifically legal aspects of the protection of marine environment, here I present you a timeline to have a picture that is certainly not complete and exhaustive, but a picture of the various steps that have led to the obligation to protect the marine environment as we stand it today. The trend of consideration of the nature and the content of this obligation over time has not always been linear, as this line seems to evoke, in the sense that while the first significant affirmation of the prohibition of transboundary harm dates back to 1941 with the smelter trial arbitration, and then in 1976, the draft articles on responsibilities of states included the protection of marine environment among the erga omnes obligations. Subsequently, we know with the revision of the draft codification of state responsibility in 2001, the reference to both crimes and erga omnes obligation were eliminated. Taking as a unitary point of reference the serious breaches. But in the meantime, however, the effects of this general assessment of the protection of marine environment as an erga omnes obligation had been produced in the inclusion of an entire chapter 12, dedicated to this theme, to this matter in the UNCLOS in 1982. And then Rio conference was really a landmark moment, because after that we had two conventions that are very important today, the Convention on Biodiversity and Convention on Climate Change, and it had a significant effect also on the UNCLOS system, because conditioned also the implementing agreement subsequent to the 1992. Then we also have had many important not many, some important cases as the pulp mills, the ICJ pulp mills case, where we where the ICJ recognized the customary nature of the obligation not to harm trout-boundary, so the so-called no harm principle. And also thanks to the three advisory opinions of the ITLOS, we have had an evolution of what is nowadays the obligation of protecting to protect the marine environment, up to the recent evolution that we heard several times that come from the advisory opinion of the ITLOS of May 2024. But let's look at the content of this obligation, because actually, if we take a look at what are the fundamental elements that characterize this obligation, we see that its mandatory nature has been defined only over time, because although the UNCLOS had already foreseen a general obligation in Article 194, however, for a long time we did not have a significant and detailed state practice that would lead us to deduce the existence of a concrete binding obligation on the part of states parties to the UNCLOS to protect the marine environment. Also because it was a matter to understand what the more detailed contents of this obligation were. So over time, we have reached a different vision, and now we know that the obligation to protect the marine environment is an erga omnes obligation, binding all states within the international community, and it is interrelated to the customary prohibition to cause transboundary damages, and it is contained in various treaties, not only in the UNCLOS, and recalled by international jurisprudence. But the very specific content of this obligation is actually today we can find it in at least 4 procedural obligations deriving from this general obligation. So those 4 procedural obligations form the concrete content of these obligations. So to date, the only existing obligations, according to me, which are capable of generating international liability for responsibility for, of the state that does not comply with them are procedural obligations. So the obligation to inform, notify other states when a form of pollution occurs that may also affect the territory or marine areas of other states or areas of the ICs. The obligation to cooperate in order to limit, contain, restore the state of the environment in the event of serious marine pollution. In addition, we have 2 elements that have been developed during the past 20 years, and that is the obligation to provide for environmental impact assessment for all activities within their jurisdiction. This has been stressed very well by the ICJ and followed by other courts, and the obligation to respect the precautionary principle or approach in all cases where there is a little scientific knowledge of the consequences of an activity at sea. And we know that also ITLOS has been very important for the affirmation of this procedural obligation as a customary one. In relation to all 4 of these procedural obligations, we know that enforcement and especially judicial practice are still poor. This has led to a certain mistrust in relation to the actual ability of this obligation to protect the marine environment, and this is maybe also the reason why nowadays we have many legal actions before national courts. But let's look now at the BBNJ that has been already mentioned and illustrated by Professor Harrison. The BBNJ, according to me, can be considered nowadays an attempt to specify which is the specific content of this obligation of protecting marine environment. In fact, first of all, we are dealing with areas beyond national jurisdiction when we deal with BBNJ, and this is an important aspect. Indeed, the obligation usually on the regulatory level takes stringent meaning when referring to areas beyond the national jurisdiction rather than within national jurisdiction. So the only no harm principle applicable within national jurisdiction is when the use of the area within national jurisdiction is provoking harm to other states. But this point is confirmed by the fact that both the fish stock agreement, the second implementing agreement to the UNCLOS, and the BBNJ, the third implementing agreement to the UNCLOS, do not regulate the environmental protection and resource conservation of the maritime zones within national jurisdiction. So this is a critical point for the protection of marine ecosystem as a whole. We are, despite we can consider the BBNJ agreement as having the main goal of marine environmental protection that is provided in the preamble, recalling the relevant provisions of the UNCLOS, including the obligation to protect the marine and to preserve marine environment. And we can really consider this agreement much more maybe a multilateral environmental agreement than an implementing agreement of the UNCLOS, because it has really the characteristics of a multilateral environmental agreement. Thus, the BBNJ agreement constitutes an autonomous and innovative major environmental agreement with a dedicated institutional structure, including COP, with regulatory powers, a secretariat, a scientific and technical body, a clearinghouse mechanism, a capacity building and transfer of marine technology committee, and an access and benefit sharing committee, and an implementation and compliance committee. So all procedural aspects that make us convincing that it is an environmental treaty. And it also provides for a complex mechanism of decision making and the first time on the ICs, with the purpose of establishing area-based management tool and marine protected areas, as has been very well illustrated by Professor Harrison. So the BBNJ agreement actually can be considered maybe as being a privileged forum for the expression of states' beliefs regarding the scope and content of the obligation to protect the marine environment in international and national practice. Therefore, the provisions of the BBNJ agreement can be considered the most recent form of definition of the content of the obligation to protect marine environment in contemporary international law. And one other aspect that I would like to underline is another key element of the negotiations was exactly the active involvement of non-governmental organizations, which that had the right to intervene during the first 3 sessions of the negotiations, and then were anyway present or as observers with the other invited international organizations and agencies. And there were also other representatives of civil society as industries, for example, representing the interests of fisheries sector or biotechnology sector. So the participation of the civil society in its complex and variegated composition represent a significant, according to me, element of pressure on the negotiating delegations, and contributed significantly to the adoption of the final text. In part, thanks to the media echo ensured in real time that was given to the ups and downs of the negotiations and to the conflicts between groups of states. Why I'm saying this and I'm underlining this? Because maybe we now are and can observe a new trend, and maybe even a sort of a new trend due to the emergence of climate change. And this trend is also confirmed by and this is a climate change chart to give an idea of the recent trend of invoking the intervention of national and international judges in matter of climate change. It was mentioned by the President so far, the high number of the judicial, national judicial action instituted in all over the world. So here there are numerous legal actions that have been started in recent years in many countries around the world. There are very different legal actions that range from those against government or to those against companies, especially oil companies accused of being responsible for climate change. And these legal actions are generally started by NGOs or group of individuals and concern the most varied fields and are often based on human rights standards. This is an increasingly widespread trend that produces a sort of domino effect. So since the famous Urgenda case decided by the Dutch Supreme Court that condemned the state of Netherlands for not having done enough to combat climate change, this case has been an inspiration for many subsequent cases. However, many of these suits have not been admitted yet and have not been accepted in the merits. So this is a trend. This is what the civil society is trying to push, but with still poor results. And anyway, it is a question of observing a trend that can have an effect in terms of contribution that international and national judges could give in the absence of conventional norms sufficient to reduce the negative impact of anthropogenic pressure on the environment. But let's go immediately to the 2024 ITLOS advisory opinion that has been mentioned several times. So we had two main questions that to them the ITLOS answered, concluding that anthropogenic greenhouse GHG emissions into the atmosphere constitute pollution of the marine environment under Article 1, Paragraph 1, Paragraph 4 of the UNCLOS. Consequently, under Article 194, Paragraph 1, state parties have specific obligation to take all necessary measures to prevent, reduce, and control marine pollution from such emissions. This includes efforts to harmonize their policies, their regulations in these regards. Concerning question 2, the tribunal emphasized that state parties are obligated to protect and preserve marine environment from the adverse effects of climate change, including ocean warming, sea level rise, and ocean acidification. So those legal questions, the decision of the advisory opinion has been adopted by the UNCLOS on the basis of the UNCLOS, but also of other rules of international law, thus confirming that an integration of different sources of international law is necessary to overcome and to fight against climate change, against environmental changes. We didn't actually, we also have this concept of that already had been introduced and described by the previous by a previous advisory opinion, the one of 2011 on the activities in the area, where the ITLOS already ruled about the concept of due diligence, and here this obligation to protect the marine environment is a matter of due diligence. So this means that the states have to take reasonable, appropriate, and proactive measures within their capabilities to fulfill their legal obligation and prevent harm. This means that states must adopt measures that are adequate, necessary, and in accordance with the best available scientific evidence to avoid, minimize pollution of the marine environment, including from sources related to climate change like anthropogenic GHG emissions. What is important is that the standard of due diligence is stringent according to this landmark advisory opinion, given the high risks of serious and irreversible harm to the marine environment. And the importance of the due diligence obligation is also that it requires states to regulate the conduct of private actors under their control. So this is much important. So we have with the due diligence obligation, it complements actually the treaty-based obligations. And I almost toward the conclusion to say that we also have recently have had several cases brought before national courts. One of them, for example, whether the Australian government owes a duty to care to Torres Strait Islanders to take reasonable steps to protect them, and further whether the Australian government has breached the alleged duty to failing to implement measures to reduce Australia's GSG. So this is still pending. There are other cases in Argentina, and we have had cases in Norway concerning specifically the applicant, the Norwegian Supreme Court that decided that was asked to review a government decision granting 10 oil production license, petroleum production in the Barents Sea, but the Supreme Court denied, and so this brought the Norwegian grandparents and other NGOs to bring the question at the issue to the European Court of Human Rights, where is still pending. So the applicants are NGOs complaining under Article 2, right to life, Article 8, right to private life, and Article of the Convention on the European Convention on Human Rights about the infringements of the Norwegian authorities of their climate obligations by their petroleum activities in Barents Sea and the Arctic Ocean. So, really to conclude now, those were just examples, and I wanted to highlight that from one side, the BBNJ on the regulatory, international regulatory level, we have the BBNJ agreement that represents a milestone for multilateralism and even urgent environmental protection of efforts, and it actually marks a wider and reinforced definition of the obligation to protect the marine environment, but it will depend on the entry into force. The capability, the power of this agreement will depend on its entry into force and on its acceptance and wide acceptance, universal acceptance by states, and also it will be very important the subsequent practice of the COP that could confirm or refine the evolution of this general obligation to protect the marine environment that is established by the UNCLOS, So this is why it is, according to me, very important to follow with maximum attention the organizational meetings of the Preparatory Commission for the entry into force of the BBNJ agreement and the convening of the first meeting of the Conference of Parties. We also have in practice these several judicial cases before advisory opinions before other international courts as the ICJ or the Inter-American Commission. So we are waiting also for them, even if we already have a landmark advisory opinion by ATLOS that marks a significant development in international environmental law, as it clarifies the responsibilities of states under UNCLOS concerning climate change-induced marine pollution. National practice shows a trend toward the extension and the straightening maybe of the obligation to protect the marine environment. So we can just conclude with some question. Are we facing an acceleration of the straightening of the obligation to protect the marine environment? Can we envisage an inseparable link from now on between environmental protection and human rights? So this integration is maybe necessary and is the future. And the last question is if this growing role of civil society and non-state actors can accelerate the transformation of the international society as we have had since now. Thank you so much.
Thank you very much, Professor Andreone, for sharing your very valuable and informative analysis of the international law with regard to the protection of the marine environment and also the climate change.